and welcome to this year's philosophy lecture series, Responsibilities to Others. My name is Joanna Kerr. I'm a librarian at London's Central Library. We're happy to partner with the Rotman Institute of Philosophy and the Department of Philosophy at Western University to bring you this program. This is our last session in this year's series. Thank you to everyone who's participated and to those who are joining us tonight. The chair of tonight's program is Eric Desjardins. Eric is the Associate Director of the Rotman Institute of Philosophy and an Associate Professor in the Department of Philosophy at Western. His research interests include the philosophy of biology, the philosophy of science, and environmental philosophy. Before Eric formally starts our program tonight, we would like to take this time together to acknowledge that we in London, Ontario are speaking to you from the traditional lands of the Anishinaabe, Haudenosaunee, Huron-Wendat, Lenape, and Neutral peoples. This land is covered by several treaties, including Treaty 6, the London Township Treaty of 1796. We acknowledge historical and ongoing injustices that Indigenous peoples endure in Canada. We are grateful for the opportunity to meet here, and we thank the generations of peoples who have taken care of this land. Together and going forward, may we recognize our own responsibility in the stewardship of this land. To learn more about Treaty 6, the library holds materials on this and other treaties. I'll include a few titles in the chat. So now I'll thank you and I'll turn it over to Eric.
Thank you very much, Joanna. Welcome back, everyone. Bonsoir à tous et à toutes. So tonight we have the honor of having a speaker who's going to take us back to some of the things we've discussed already in the first talk. So where we started with altruism from a biological perspective. So we're going back to this biological world, but this time from the legal perspective. So our speaker tonight, Maneesha Deckha, is professor and Lansdowne Chair in Law at the University of Victoria. And her research interests include animal law, feminist theory, critical animal studies, vulnerability studies, health law, bioethics, and reproductive policy. And so tonight she's going to talk about Animal as Legal Being, which is the title of a book that is soon to be published. And she's going to tell us a little bit about what's in that book. But before we do so, I just would like to remind you that this session tonight, this talk is being recorded and is live. And so the way it's going to work is that we're first going to hear Maneesha give her talk, and then there's going to be a Q&A session period after that. So if you have a question for the speaker, I invite you to use the Q&A function, so at the bottom of your screen there. And if you have any questions related to technicalities, then you can use the chat function and someone is going to answer your question. So with no further ado, I would like to invite Maneesha to start her presentation.
Thank you so much, Eric. And thank you to the Rotman Institute, to Western University, and to the London Public Library for this very lovely invitation. I'm delighted to be here, and thank you to all of you for joining me. And I would also like to acknowledge that myself and my university, the University of Victoria, is situated on the traditional territories of the Lekwungen peoples, and also acknowledge that the relationship that the Songhees, Esquimalt, and Wasanich nations have with the land today remains profound. And I'm very grateful to be sitting here in these beautiful territories and sharing my monograph project that will soon be released by the University of Toronto Press. So I will just share my screen. So as Professor Desjardins said, this is a talk that is just called after my book project, which is Animals as Legal Beings, Contesting Anthropocentric Legal Orders. So what I'd like to do is to give you a sense of the book. by looking first at the purposes I had in writing the book and some central departure points, then to take you through the main arguments through part 1 and part 2, and then to round out with some conclusions and an example of what a new legal order would mean for the most exploited animals in my and other people's opinions who write in this area, the farmed animals, the animals caught in the animal agriculture in terms of numbers in Canada. All right. Okay, so the field that I'm writing from in North American circles is called animal law. And there's quite a lot of writing, just every year, more and more literature scholarship coming out in this area, largely from the United States and American law schools, but also Canadian law schools. And the purpose that I had in this book was to argue against one of the central kind of taken for granted departure points about what animals' legal status should be by animal-friendly advocates, which is personhood. So animal law advocates, animal rights scholars take issue with the current legal status for animals in the Canadian common law and the civil law, the status of property. And I also take issue with that. But instead of arguing for personhood for animals, which is basically the alternative in the common law, we are either property or persons. And it's a very binary system. There's no real in between. I argue for something called beingness, which I see as a more transformative legal status for animals than just personhood. And an ancillary or secondary purpose of this book was to bring into animal law conversations more of the kind of human rights, critical theory type of frameworks that are very familiar in feminist circles, in anti-colonial circles, in queer scholarship, in Marxist theory, in disability rights theory, but wasn't too integrated into animal law conversations about how the law should change for animals. This scholarship was more informed by liberalism. So basically the book takes issue with certain forms of liberalism and how they've shaped our vision as to what might be possible for animals. So that was a secondary purpose too, to kind of meld more critical thinking with animal law thinking. And so in the introduction, I have to do a lot of caveats, and I set out a lot of presumptions, and I'll just go over a few to give you a sense of that kind of laying the groundwork. So the first, of course, is to acknowledge that any transformation of law is still going to be an anthropocentric endeavor because it is humans, however well-intentioned, doing it. So just want to acknowledge from the get-go, the law is invariably anthropocentric, and vis-a-vis animals who perhaps aren't asking for our help and aren't acquiescing to whatever reform we come up with, can still be very colonizing from their perspective. At the same time, when you consider what the legal property status of animals enables in terms of their use, both by human actors, but mostly corporate actors, it's really, in my opinion, and others have also argued, very abysmal and staggering in terms of the rates of violence and misery that these institutions, some call the animal industrial complex, occasion for animals. So I do think that it's still worth engaging with law, as human-centered as it is, to try to make it less so. The second main departure point is to say that the critique I'm leveling is against legal orders, so legal systems that are anthropocentric, so that take really a human-first approach and exalt the human and really don't think of other corporate actors as persons, except perhaps revealingly corporations and chips. That is the common law in terms of who can be a person. So notably, The argument is not directed at, for example, in Canada, Indigenous legal orders, and not to say that critiques cannot be made of these orders as well, or that they are completely non-anthropocentric, but my focus is on trying to look at mainstream, dominant, industrial use of animals and exposing how the law facilitates that use, and then suggesting how it could change for better harmonious interspecies relations. So it's focused on criticizing common law systems and other jurisdictions around the world that take their timber and legacy from the British common law. And a third departure point I'll just mention is just this, the language we use when I'm talking about animals. There's a lot of scholarship that, tries to get our attention that in the English language, we have one word that's supposed to encapsulate just billions of species in that concept, and then we reserve the word human as something separate from all of these other beings on the planet, and that itself kind of sets up a human referencing point or human benchmark that is guilty of anthropocentrism itself. And I certainly agree with that. So this concern about just what to call animals has led some people to suggest alternatives. You've likely heard them: non-human animals, other than humans, more than humans, different spelling of the word animal. I think those are all, worthy projects for shorthand and convenience. I do primarily use the term animal, and that's why I'm using it here in the book and in the talk right now. Okay, so part one is entitled Beyond Property and Personhood. Okay, so in this part, I have 3 chapters, which basically say 3 main things. Chapter 1 is the chapter where, I show, and it's very easy to show this, how in the common law, animals are property. But the chapter is directed more at the perception that many of us have before we kind of get into this area, that the law protects animals. How? Through anti-cruelty statutes, primarily. And so this is a chapter that really shows that anti-cruelty statutes really protect nothing. They are not designed for animals. They came out of a history designed for human owners, to protect human owners of animals from interference with their property rights in their animals by other owners. And it's also very interesting to see how anti-cruelty statutes align also with class-based politics and imperialism. So, and we can, even that's more of a historical imprint, we can still see that imprint manifesting today in more recent times, because when you look at the cases where there have been convictions for anti-cruelty or for cruelty through anti-cruelty statutes, it is primarily whatever is seen by the dominant culture to be culturally aberrant. So examples of, tying your dog behind a truck and, driving the truck, putting cats in microwaves, all these horrible, activities that the dominant culture finds horrible. But yet the kind of institutional use of animals that entail the same level of pain and misery, or even more, that's normalized and never really comes under the radar of anti-cruelty statutes. And most of these anti-cruelty statutes either have an explicit exemption built in to not apply to, for example, agriculture and husbandry practices or research, or an implicit exemption is read in when these statutes come into a court for interpretation. So chapter 1 is aimed at showing how property status of animals facilitates their use and exploitation in human society and by corporations. So then I come to part of the book, which I think will be a surprise for many of those interested in animal rights and supportive of animal rights, and who have heard that, well, the antidote to property in the common law would be to make animals legal persons. So, you and I, we're all legal persons in the eyes of the law. And so what does that give us? It gives us like protection against instrumental treatment by others. So to have a right is, to put it in a certain scholarship frame, it's like a trump card against any type of government interference that would not be for our benefit, of a certain magnitude, i.e. we have rights to life, liberty, security of the person, for example, and which are not to be interfered with except when really necessary, and then only within certain parameters. Okay, so I argue against personhood in chapter 2, and here I look at where did the idea of personhood come out from, and I make the argument that it's actually, given this history, not very animal friendly. So I'll say more about that in a moment. And then chapter 3 is a chapter where I lay out a few other major shifts that the common law needs to undergo before it would be able to really embrace a new legal status for animals that I'm calling beingness. So just to give a bit more context to chapter 2, because it's often hard to understand, well, what's wrong with personhood? Like, we're all persons. Well, when we look at legal texts, judgments from courts, or even legislation from legislatures, from elected officials, we can see that personhood is a very elusive concept. It's rarely defined, although it's so ubiquitous, and it's just like this presumptive departure point. And I don't want to suggest that there's one understanding of personhood, but a very strong understanding of personhood across common law jurisdictions, for example, Canada, Australia, New Zealand, United Kingdom, India, for example, is this idea of the paradigmatic person. Who is that person, right? If we all closed our eyes and thought, when we hear the word person in law, who's there? Who do we envision? Well, it's a person who is hyper-rational, who can reason at a certain level, basically doesn't have a body or any type of social location that grounds them in any way, and that is also hyper-independent, doesn't need anyone else to kind of manage their life and go forward. And as a lot of critical theory, just worried about how marginalized human groups are treated, point out, this idea of laws person actually doesn't resonate for most of humanity. And I take that critique to say, well, it really doesn't resonate with most of the animal world either, if we think of those as binaries. And then I go into arguments about, well, can you recuperate or rehabilitate this idea of personhood for animals? And I basically suggest no, that if you look into the history, personhood is so kind of shaped by this liberal idea of being just of the mind and having a certain rational capacity. And it's so kind of embedded in discourses around civilization and empire building and who matters and who doesn't, that not only is it hard to get away from to revise for more like equitable connotations and animal-friendly connotations, but actually the person property divide in the common law, right? So the common law divides all of us up into persons or property, and most things are property, and persons are just human beings, corporations, and ships. That divide is actually constituted by the human-animal divide. So I draw on scholarship to make that argument, to say it's not just a matter of like moving animals from the property realm to the person realm. It doesn't even make sense, because the person-property divide is made up of the human-animal divide. And really, at the end of the day, I said, even trying to get personhood for animals is so radical and revolutionary that if we're trying to, as animal advocates, to get a better status for animals in the law, to have them be better treated, either, full stop, or at least in certain industries, why don't we just theorize something new from, first principles that would be more animal friendly than personhood? And so that's when I go into beingness. But before just outlining beingness, I just want to acknowledge that, of course, there are other shifts that would have to happen in our legal system to make it more animal friendly, really to make it more friendly to like most beings, humans included. What are those? Well, currently there's a disdain for emotions. Any type of emotional based reasoning is seen as illegitimate, or even the idea that humans make make rational decisions based on emotions, that our reasoning capacities are not divorced from our affective or emotional capacities. Like that's not, those insights from neuroscience aren't integrated into the law. And there's a whole scholarship called Law and Emotions Literature that is trying to popularize that more and get more legal recognition that reasoning entails reasoning from emotions. But there's still a lot of work to be done on that. And of course, the second point is that we're a very rights-based system. And when we hear the word rights, we usually think of, as the law teaches us to do, to think of our entitlement. And of course, that has its place. But at the same time, when we're a rights-based society, we are not taught to think of our responsibilities to others or our accountability to others, either en masse or to individualize others. So I talk about the need for that shift as well in terms of the legal system. And finally, I come back to this idea that we really need to focus on power asymmetries that we normally don't see, like our asymmetries at a species level in terms of human beings and the rest of the world, and the need to disrupt that kind of invisibility by attending to the materiality of our bodies and the pain that they can go through. All of which, doesn't receive a lot of conversation in legal texts. Okay, so then part 2 sets out the new legal subjectivity that I am advocating for, which I call animals as legal beings. And so chapter 4 sets out that the constitutive features of the new status, which I'll go over. And then chapter 5 anticipates the major criticisms and hopefully gives convincing kind of replies to those critiques. So let's just go over this. Okay, so beingness, what does that even mean? Like, what is this new status? Well, first, let's get a handle on personhood. What does it mean to be a legal person? Well, as I've suggested earlier, we can think of, if we had features of personhood, even though it's quite an elusive concept that, for its importance in the law, doesn't get discussed much at all. But to be a person really is to be a disembodied actor, so to not have a body, again, to be hyper-rational and to be seen as completely independent, right? And we know that most of us don't inhabit this or don't meet these criteria. Certainly, we all come into this world dependent, and many of us will go exit from this world dependent on others. And it's not the case that all of us have this, hyper rationality, either, as young people or at other points in our lifespan either. And of course, it's not the case that we are disembodied. We all have a body, and there's cultural meanings attached to our bodies in terms of markers of gender, of race, of sexuality, of gender identity, class, of ability. Okay, so, but yet again, personhood doesn't really see that. The idea of lost person is just about someone being a reasonable person and thinking in a certain way. How would beingness change this status? Like, what would it mean to be a being rather than a person for animals? Another way to put that is, what features of ourselves would the law direct attention to if we saw animals as beings, right? So of course, the departure point for this chart is that we don't want to see animals as property, which is basically not seeing animals in the law. Because when we're property in the law, we're nothing. We're not a legal subject. We're just, objects to which property rights attach. The law cannot see you as property because you are nothing, right? But in persons, we are just seen as rational self-maximizers. If we were beings, or specifically if animals are beings, what then would the law pay attention to? Well, kind of as a parallel to each of the features on the left column, to our embodiment, to our vulnerability, and to our relationality. And so in this chapter, I look at a lot of the critical theory from relational theory, from feminist theory, from vulnerability studies, from disability theory, from anti-colonial theory, post-colonial theory, where a lot of scholars who are focused on the human realm of human injustices make the argument that we really have to come back to these features of ourselves as human beings to be responsive to the injustices that are pervading our society. And I take that scholarship and say, well, there's nothing that in these arguments that prevent them from being extended to animals. Animals are also embodied, animals are also vulnerable, and animals are also relational. And so the arguments that are very persuasive in the human rights context as to why we should care about marginalized human groups and why we should have a different outlook in terms of how to respond to need, how to respond to vulnerability, makes sense for animals as well. And so that's how I can construct the argument of what a being would mean and why it makes sense to extend that status to animals. And chapter 5 then considers, what are some criticisms of this from a particular vantage point. So the book up to this point takes issue with liberal humanism, right? So just to remind us all of, one of my purposes in writing this book was to kind of bring a critique of liberalism that's very popular in, for example, feminist theory, for example, or anti-colonial theory, into animal law circles where it really didn't receive a lot of traction. And why did I want to do that? Well, because a lot of the animal law reform that goes forward is still very tethered to liberal ideas of dignity, equality, and autonomy, classic liberal values, right, which are in our Charter for Human Beings and which we talk about. But how they usually play out in legal reform is to apply those concepts to the most humanized animals in any society. So if we take Canadian society, like en masse, we can generalize. I think it's a fair generalization to say, the humanized animals would be like dogs, cats, whales, great apes, elephants, right? And then in any society, you have the animalized animals, the ones that don't get to be like honorary humans and for whom there isn't a strong public support to change their lives for the better. So, for example, the farmed animals, right? So animal law, as it's traditionally kind of articulated now, whether it's in like groundbreaking litigation or in, trying to get legislation passed for some animals, usually takes the honorary humans, the animals that people can relate to, like the mega fauna, for example, like whales, and advocates for them by saying, look, they're just like humans. Right. And that's an argument I'm trying to get away from. And I'm saying is problematic about liberal humanism, because we shouldn't have to be like this paradigmatic, human person for all of us to count and matter ethically or legally. So in this chapter, I ask, have I actually in, stipulating beingness for animals actually reproduce a certain variation of liberal humanism? And another way to see what I'm asking here is just to consider the question, what about plants? Right? Because that is certainly the most popular question I get whenever I give a talk on animals. And I know I'm not alone in this in terms of other animal scholars also receiving this question. So what about plants, right? What am I arguing against? I'm arguing against a humans above everything else line. Am I just moving the line down to humans and animals above everything else in the world, like plants, like other non-humans? And so I don't think I am. And in this chapter, I make the case for why not. And for me, this was the most kind of uncharted chapter because there's not a lot of scholarship addressing this point. And I would just speculate that's because so many of us who care about animals we're trying to make the case for animals in a very anthropocentric kind of, world, whether it's in academia or otherwise. But here, I learned a lot about plants and trees, and from the emerging literature about plants and how we, wrongly objectify them. And I end up not extending beingness to plants, just because I want beingness to be a status for animals that is as protective as personhood is meant to be, right? So as legal persons, we're not supposed to be amenable to exploitation against our consent, really. And even sometimes the law doesn't let us even consent to our own kind of exploitation. That isn't possible for plants, even though we might want to have a different regard than we do as just mere property, and to implement that in the law, because of course it is difficult to understand how the world can go forward if humans and animals aren't eating plants. So that's why I don't ascribe beingness to plants, although I try to be clear that their status can also change from property to something else. That would connote more respect, but in the end would still entail their consumption. And then finally, in chapter 6, I provide a conclusion, and I give a little bit of example of how would this work, right? Okay, so I, kind of wrap up or encapsulate, remind the reader that beingness, there is a difference if animals were beings as opposed to if they're property, and even if they were persons. And I talk about examples. It's not the case that we all have one monolithic view toward animals. There are many examples where, even in current society, we show care for animals that clearly show we don't think of them as property. And this was an example of horses dying in a barn fire, where the Globe and Mail, the National Post, front line headlines had obituaries for these horses. And that shows a type of grievability about, whose life is worth grieving. When do we grieve lives? Not just for humans. At the same time, beingness is meant to get us to a place in the law where we're not just grieving the humanized animals, the honorary human animals like horses or whales or elephants, as important and as miserable as their lives can be in captivity. Or as much as they can suffer in a barn fire, but to get to also the farmed animals, the research animals that we don't hear a lot about and aren't grieving for, who are dying like in the billions, or at least in the millions. Then I talk about what are the first steps that the law we could actually implement in law, like starting tomorrow if this was to happen. So there's certain, obviously, prohibitions against the use of animals, but I also talk about ways to think about how human beings, as policy analysts, as lawyers, as judges, as politicians, can start thinking in a more multi-species way for animals. So the main guiding principles here would be to have a prohibition on human or corporate trade in animals or animal products. Of course, that would be wide sweeping, right? Just drastically change society. To have interpretive principles about rejecting anthropocentrism, to inculcate more of multi-species thinking, and to have ways to listen and respond to animals instead of just thinking that's impossible. So I remind the reader, that we already have in the law environmental impact assessments to try to take the perspective of the environment. All right, so in a type of non-human in our decision making, and we also in trying to take perspective of individuals who may not have legal capacity because of compromised reasoning abilities, this model called supported decision making. So this is all to say that already in law, there's a way to think of non-rational actors, maybe actors for whom we can't get verbal responses as to what they want and what they would like, in a way to bring in their interests and to carry them forward. And I'd also draw from feminist theory and interesting like ethnography in multi-species contexts to think of how we can start thinking about listening with animals and partnering with them. Again, new ideas, but not unheard of in terms of how to move forward. And then finally, I give an example of, what would this mean? So if tomorrow the law changed and animals were beings, you would have had then animals that have gone into, for example, factory farming, the farm animal system as property, but because they're beings, their kind of, assembly line role up until slaughter would change. And all of a sudden we would have all these animals on our hands because of the number of farmed animals in any given moment in Canada is enormous. And there's a estimate below there. How can we deal with these animals? The book thinks about what it would mean to care for them and brings up some nuanced questions there. And in the meantime, what can we do? And drawing from the concept of bearing witness, I argue that this is something important to do, even as much as our current laws try to prevent us from bearing witness. It's quite notable that Canada, during the time of COVID, brought in ag legislation, which was very popular in the United States and struck down in many states there. What is this legislation? This prevents whistleblowing in farming contexts, and it also prevents animal rights activists or others who care about animals to try to commune with them and bear witness to their suffering in that rare moment, public moment, when animals are transferred from a concentrated animal feeding operation to the slaughterhouse when they might be outside in a truck. That now is illegal in certain jurisdictions. And I end the book with the reminder that it is possible to think differently for animals and what their lives could be, even for farmed animals. There's a beautiful book called The Cow with Ear Tag, 1389, by Catherine Gillespie. This was her dissertation in the Pacific Northwest. She tried to get access to dairy farms, but couldn't. But she ended up writing a book anyway about the whole dairy industry. And she named her book after a cow that she saw collapse and then eventually die shortly after that. In the only space where we can access animals in this industry as members of the public, which is in the auction hall. And she talks about, in the last pages of her book, a cow named Sadie and the completely different experience she had in sanctuary. And I just extracted that paragraph here. And so I would just close with reminding ourselves that, we're living in a moment where it's coming clearer that how much human health is tied up with how we treat other species on this planet, in this world. And it's also becoming clear that when we want to, and politicians want to, when the public accepts it, it is possible to have wide-scale change very quickly, and to kind of think that animals always have to be in these industries, and we always have to be following the same modalities, whether it's research or farming or entertainment, I think is a very limited view of what is possible. Thank you so much, and I'll invite your questions and comments.
Thank you very much for this fascinating talk, provocative ideas. I really enjoyed it. So now we're going to start the Q&A session. So I invite you to write down your question using the Q&A function. And so we're going to do our best to bring your question to the front, but so it depends. We never know. We might have a lot of questions and we might not make it to the end of the list. And we're also trying to regroup them a little bit when it's possible. So if you just give me a moment here, I think we have already some questions coming from the Q&A here. So the first one from Chava. So as someone who acknowledges animals as sentient beings, how do you deal with the fact that you work in a university which conducts research on animals?
Okay, yes. Thank you so much for this question. Yeah, I have those personal moments of feeling very compromised in the job I have. And I usually tell myself that it could be a lot worse in terms of the employer I have. And I try to make myself feel better by saying, well, the whole purpose of my work, so much of it is on animals, is to write about them, is to teach, is to kind of inspire critical thinking, that hopefully is making some impact. And I also try to make links with others on campus that are, and not just my campus, but elsewhere, that are trying to really teach people about the inefficacy of animal experimentation as kind of a gold standard in biomedical research. So actually, I just happen to have, I will just give a plug out to, if you haven't read this book or come across the work of Aisha Attar. She's a medical doctor, a neurologist, and a public health specialist. This is her first book, her second book, Our Symphony with Animals. Her first book, Animals and Public Health. She has a wonderful chapter on just really how inefficacious animal research is. So try to collaborate with her and other professionals who really kind of have the scientific credentials to convince the public of what they're saying about the harm actually in using animal-based models for human health outcomes.
Yeah, I guess education is key here. But so our next question from Paul, who's thanking you for the presentation. He says that he's sympathetic but also curious. So the question revolves around in comparing the status or rights of two types of beings, or using the theory of beingness. So how we apply them, let's say, to amoeba or shrimp. Would they have more rights or greater rights or status than, let's say, 100-year-old tree? So does it imply that?
Right. Thank
you.
You.
Repeat if you're not clear on this.
No, I hopefully I got it. Thank you for the question as well. So this is actually, I take this up in that chapter 5, which, we could call the What About Plants chapter, but I just don't discuss plants. I actually discuss really interesting scholarship about robots, about other types of non-humans, like which in, other legal orders would be seen as persons already, like mountains, rivers, other bodies of water. And what I try to make clear is that even within like the animal world of animals that would be qualifying for beingness, so whether it's like mammals like the great apes or insects, I say that there shouldn't be a ranking of capacity, which is what normally happens. We think of our why are humans said to be special? It usually comes back to arguments about we have better X, right? Or we're the only ones who can do Y. And so this narrative has changed over the years as actually science has shown, oh no, actually these animals can do X and these animals can do Y. But how do we keep shoring up our system of human exceptionalism? We say, well, there's certain things that only humans can do, and that's why we're more important. And that's like a capacity-based system, right? If you have X, then you get moral status or you get legal status. So this model is trying to get away from that capacity-based system. But then I asked the question, well, does that mean that capacities don't matter? Like, does sentience not matter? If it's like a contest, let's say, between a non-sentient being, let's say a rock, right? And not everyone will agree a rock is not sentient. I don't want to exclude that. But a sentient animal, can we advert to sentience? I say, yes, of course we can, and we should. But it doesn't mean we have to say the rock doesn't matter or that the rock is somehow lesser. So I want to get out of the hierarchical ordering of the whole world, which is very much what our legal system is premised on, because it is fundamentally anthropocentric, and has a version of human dignity that relies on there being a lower other, i.e. non-humans, right? To have a way to say all beings can matter, but that it would still be legitimate when we're trying to respond to different needs, to look at our capacities to figure out what it is that we need.
Yeah, thank you. So next question from Brendan. So Brendan, I apologize, I'm gonna remove some part of your question. He's curious about cats, roaming cats, partly, but I really like the end of your question here, where you're asking about the beingness of individuals as who might have rights, and compare this to whole species or ecosystems. So what I understand the question being about here is partly like there's the framework, as you suggest, kind of opens up from, let's say, personhood to beings. And so can we even go further and include other things? You already talked about plants, but here, so it sounds like perhaps there's kind of a further opening that might be happening.
Yes. So the argument is not to say it should close here, but I try to focus the argument on animals in the book by saying that, of course, it could be extended to other types of non-human beings, although I don't make do that specific analytical work in the book to show why. But if the question is the general sense or orientation of the book trying to be open-minded about others that have been excluded, other non-humans, then yes, I hope that that does come across in the book, because that is what I intended, even though the focus and the specific argumentation is about animals.
Yeah. So we have here a question that I don't know whether you're going to be able to answer. Maybe I would not, because it refers to a certain type of law. So I'm going to ask it, but if you don't know anything about that law, maybe. So the question is from Drishti, and so Drishti wants to ask about the ag-gag law. So, and is there something which we can do about it? But so, are you familiar with the ag-gag law?
Yeah, so it's what
maybe you can tell us a little bit more about that law as well.
Right. So ag-gag laws are kind of, the colloquial way or layperson way referring to legislation that tries to illegalize members of the public from approaching farms or operations associated with animal agriculture, and also illegalizes any one of us going undercover at basically getting hired as an employee for the purpose or eventual purpose of taking footage to then share publicly for what's going on there. And so that then now we can understand kind of its name, ag-gag, right? It's gagging us from basically disclosing what many of us see as the truth of these places as horrible places of misery. And so that hadn't happened in Canada and until very recently. So Alberta basically just rushed that law through, I think within 10 days, about a year ago now. And Ontario did that in June. After coverage was quite prominent on the New York Times, even the Globe and Mail, about how fast the speed lines are in intensive agriculture and how many animals now could not go to slaughter because they're getting too large to go to the slaughterhouse and be slaughtered according to like that, just the size of instruments and apparatuses there, and how many animals were killed by other means, and then how precarious the human workers are in these places and what is happening to them. And Ontario passed, right, basically anti-whistleblowing legislation about not exposing what's going on in these places. So what to do about it? Well, I'm involved with a group called Animal Justice, and they are kind of a newer, legally oriented advocacy group. Animaljustice.ca is their website, and they have very good campaigning and ideas of how to get involved. Obviously, I'll give an example where legislation was successful for and favor of animals, and that was the ending of the captivity of whales and dolphins bill that eventually became law last summer. So, it doesn't take current cetaceans out of captivity, but at least it stops new cetaceans from coming into captivity. And now, as some of our participants may know, the Jane Goodall Act has been introduced by Senator Murray Sinclair in the Senate. And that is now seeking to have the same idea about new captivity for great apes and elephants, and also banning ivory imports, and also the use of these animals for rides like at African lion safari and so forth. Okay, how did the whale bill, it was called, almost failed, right? And took a massive groundswell of grassroots support, people calling people writing, the petition, social media. And I would say that's what's going to be needed for anyone who wants to support the Jane Goodall Act for it to go through, especially in this minority parliament. So that is something immediate to do about Ag Act legislation. And of course, the other thing to do is really to vote or to influence with your fork. I am a believer in that. This industry tracks what we eat, and you can see how you have Tyson Foods and other big animal agriculture users taking over the plant-based lines, right, of like fake meats and other plant-based products. And so that's another way of signaling consumer kind of appetite and consumer intentions. So I do think it all aggregates into kind of a shift that then enables something like the Jane Goodall Act to come forward. So right now we don't see obviously anything for farmed animals, but society does evolve at some points, and it does. Politicians need to see us as caring about certain issues to take the action.
So our next question from Clifford, who thanks you for the talk and who's also from Vancouver Island. And so I particularly appreciated your starting distinction that law is inherently anthropocentric and colonial, but that nevertheless some legal changes necessary to better animals' current miserable status. So he was wondering, could you further clarify how lawmakers can accurately assess the notion of what is good or better for animals without becoming what he called impositional and anthropocentric?
Yes, yeah. Thank you for this question as well. And I mean, on all the previous questions. So this is what I tried to get to in chapter 6. And so I take one example, let's say, of the supported decision-making model. So some of us may be aware, like when a human being is seen to be mentally incapable of articulating their own needs, or someone's been in an accident and for a temporary period can't communicate to a doctor or to a nurse what they want. We usually, what type of system do we have in place? A substitute decision-making model. This is legislation in all our provincial and territorial jurisdictions. So another person substitutes for us when we are not able to communicate our own consent or our own viewpoints. And in disability rights advocacy, there is a critique of substitute decision-making because often it reverts to a best interest model where you have the substitute proxy decision-maker. If you've never spoken with your loved one about what they would want in the situation, you either try to really imagine what it is or you do what's in their best interests, right? And that can be paternalistic some ways when it's kind of an institutional relationship, let's say, of human beings trying to do what's right for animals, but perhaps acting too paternalistically about what's in their best interest. So how could I think what we need to do as, future human policymakers trying to think about how to make an animal-friendly decision is to get into a supported decision-making model. What does supported mean? It's to start off by understanding that just because an animal is not speaking our language or we're not speaking their language doesn't mean there's no communication that's not possible. Even among humans, right? Communication theory shows a lot of communication happens non-verbally in terms of social communication, and language is just one ingredient of communicating. And we know that if we've ever been around human babies, right? We're not yet speaking. Okay. And many of us know that animals also communicate, even though we're not speaking their languages, and we understand our dogs and this and that. Okay. But now this is the thing. How do we know we really understand our dogs? Well, we have to think, right? How can we listen to them? And this is where in the book I draw upon the new field of multi-species ethnography. So where researchers are really trying to look at animal communities to see kind of the cultural practices there and how animals relate and communicate, and give examples that it is possible to listen. And if we, put ourselves in a certain mindset, of course, we're never going to know for sure that we've got it right. But even now, even if I'm speaking with you or you're speaking with me, I never know for sure if what it was in the entirety of your mind and you communicate to me is 100% what I received. of you saying in the communication or even through written text, right? So it may be easier human to human, let's say, on a general basis, but it's still challenging, right? Communication is still challenging. So that's how I would approach it. I think to be optimistic that we can listen and have a partnership rather than just saying animals can't communicate, they're passive, there's no way we can read what they want, so let's just do in their best interests. That's much better than what happens now, which is not to think of them at all, or just as in endangered species legislation, let's say. But I think that we can be optimistic and people can learn to do it better. It's a skill that can be cultivated.
Yeah, I must say I really like the way you present the beingness, and when you show the three components of the beingness, and when you introduce this notion of relationality, that I think that makes a lot of sense. And then what you just said there, if you start looking at animals or beings as relational, then you start like maybe looking at avenues that are slightly different and will bring, I would say, more humane, but maybe not approach to treating them, or better ways of treating them. Yeah, humane would not be appropriate here. So the next question from Boris. Boris is asking, this is a kind of a radical argument that you're making here, but what do you see as the possibility of beingness having a practical effect anytime soon?
Yes, thank you for that question. Well, I mean, I do think the new Jane Goodall Act is quite a radical act. And the idea of being, like, it's not, animals aren't called legal beings. They're not taken out of their property categorization. But I had the opportunity to speak to one of the parliamentary actors in Senator Sinclair's office, and he called the act transitional in terms of kind of how it, and which all kind of law is. We get an idea of what's possible when something happens, right? Like, so cannabis is legalized. So, and then we all live in a world where cannabis is legalized, and now Vancouver City is advocating for all drugs, simple possession of all drugs, to be legalized, right? And so this is transitional, this idea of opening the door. And if you look at this act, it does certain really groundbreaking things, which I've written about in certain other contexts. First of all, it in the preamble, so that part of the law where it doesn't really count as law in terms of like specific numbered provisions, but it sets out kind of, here are the grand principles, the lofty ideas we're trying to respect by bringing in this law. And the first one that's mentioned is the Indigenous idea, right? Or idea in many Indigenous societies, worldviews, legal orders, of the idea of all our relations, right? That we're a multi-species community, animals are our kin, animals are our relations. So already that's a different idea of animals and property than the Western common law idea of property. And so, I mean, if that act passes, that would be really groundbreaking for that kind of just statement. Yes, the elephants, the great apes are still classified as property in the Canadian legal system, but at least you have some like legal grounding for a future court or future piece of legislation to tack onto to say we need to start thinking of animals as different beings. You saw Senator Sinclair took on the whale bill and also supported it, and gave the same argument, similar ideas about Indigenous teachings tell us we have to decenter the human, and the whale is my kin, right? And this is not the way to treat whales. And so this is now coming to elephants, to great apes. And if we're, as I've written in a separate article, if we're serious in Canada about decolonizing our legal system and not just thinking of the bijural system of common law and civil law and our colonial kind of inheritors with the British and the French, and we really want to place Indigenous legal orders at the same level, which is kind of what is meant by decolonization and even certain more robust sense of reconciliation, then many indigenous legal orders give animals a way higher status, right? They're not property. And so already we have in Canada, when we look to these legal orders as law, which is the mindset we're trying to cultivate, at least in our law school, many other law schools, in the law societies as well. Then they're already there are already legal examples. It's just a matter of getting them into the dominant legal systems like the common law to have, as we say, more wide-reaching or practical effect. And I think the Jane Goodall Act is the first area where we see that. What's also very interesting with the Jane Goodall Act, I'll just make this my last comment, I see the time, is normally, kind of the response is that, oh, well, animal rights and animal issues are like antithetical to Indigenous rights and Indigenous issues because everyone often thinks of the subsistence hunting question. But what's really groundbreaking in the Jane Goodall Act is that interpretively, like the legislation often gives, statements about this should be seen this way. And in this act, it says the protection for animals should be seen as supporting and promoting Indigenous worldviews rather than detracting from them. And that is, a real strong pushback to that critique that somehow doing better by animals is against Indigenous teachings, which, never made really any sense to me, but was a popular viewpoint.
Yeah, I agree with you here. Well, on those very wise last words, I would like to thank you. So we're going to clap in our little box here for this wonderful talk and for these generous answers that you provided to us. And I would like to thank everyone for joining us again. Thank the library, and special thank to Deborah and Laura in the background who have been working, making all of this running smoothly and helping organizing all this event. So thanks everyone, and until next time, take care.